So my name is Paul Lanois, and I'm going to talk to you today about privacy. So we are going to be talking about the Fortnite case as well, but then it was already covered this morning, so I'm not going to spend too much time on it, but it is still relevant, obviously, to the gaming industry. Before I begin who I am, so I'm Paul Lanois. I am a director at the European law firm Fieldfisher. I'm based in California. And I advise clients in relation to privacy, data protection, and cybersecurity law. So I mentioned I'm based in California now, and before joining Fieldfisher, I was working in Switzerland and in Hong Kong. I was with an international bank, Credit Suisse, where I was vice president and senior legal counsel. And before that, I've worked at European law firms in the United Kingdom, in France, and in Luxembourg. In relation specifically to the gaming industry, so I work a lot with clients across different industries, as well as game developers, game publishers, as well as manufacturers of certain gaming-related devices. I'm thinking about virtual reality headsets and so forth, as well as manufacturers of connected devices and augmented reality software as well. So let's begin. So privacy is in the news a lot. I'm sure you've seen some of the headlines over the past couple of weeks, months, years. So I've put here, some of the recent headlines, and as you can see, there have been quite a number of high-profile cases. AI, for example, since everyone is talking about AI these days, you had this decision from the Italian authority last month where they had initially banned the use of ChatGPT in Italy because they say that ChatGPT did not comply with the European General Data Protection Regulation, the GDPR, and there were issues as well in relation to children being allowed on the platform and so forth. So those issues have now been resolved. So now ChatGPT is back online in Italy. But they did have to make quite a number of substantive changes as well to their privacy policies. The notices, now they have also committed to implement certain parental consent and to restrict as well the use of the platform to children. There are quite a number of decisions as well in relation to social media platforms, TikTok, Meta, as well as apps which are used for communication, WhatsApp. As you can see here, there was a fine of 225 million euros against WhatsApp. Amazon had a record fine of $888 million as well in relation to the deployment of cookies without getting consent from the users. So you really have lots of incidents in relation to privacy. But then many of you may be saying, well, okay, that's nice, but what about the gaming industry specifically? And what are the cases? What are the big decisions? Well, you do have, of course, the Fortnite case, whereby Epic Games, the developer of Fortnite, they were required to pay $520 million in total in relation to certain privacy violations. There was a component in relation to children because there wasn't any control in relation to children being allowed onto the platform, and then there were also certain practices, what the regulators call dark patterns, whereby certain design choices were deemed to be misleading and to be predatory as well. So we'll talk about it later on as well. There is as well a case in relation to a Swiss game developer, Miniclip, which was which took place with the FTC. So you may be wondering, well, wait a minute, why is the US FTC, the US Federal Trade Commission, going after a Swiss game developer? What's the connection? And what happened here was that you have this game developer who indicated in their privacy policy that they were a member of the Cooper Safe Harbor program. So it's a program whereby you have to commit to certain privacy commitments, and you have to register with the FTC, and then they would monitor you and so forth. And what happened was that the company was initially a member of this program, and then they decided, you know what, we're going to leave, but then they didn't update their privacy policy. They just left it as it is. And then the FTC said, you know, this is misleading. This, you know, if you're no longer a part of the program, fine, but then you have to remove it from your privacy policy and so forth. So that's the reason why you have this Swiss game developer who is on the list. And you know, this brings me to the to another point that I want to mention as well, is that in many cases you have game developers who would use a privacy policy that they found online from somebody else. You know, they would say, you know what, it's too complicated. I'm just going to do a copy and paste of another game developer because they're doing something similar to what I'm doing, and you know, it looks nice, so I'll just copy and paste, and then I'll use it as my own privacy policy. So that's something that we see a lot, and unfortunately, in many cases, it does lead to problems down the road because you know, they haven't really considered the content of the privacy policy. Maybe the company is doing slightly different things. They may not be collecting the same types of data, or they may be using the data for another purpose. And you know, if that's the case, then the privacy policy would be deemed misleading, and you know, this could lead to sanctions as well under data protection laws. So, you know, I'm sure many of you have heard of the GDPR, the European General Data Protection Regulation in the EU, and you may be thinking, well, okay, well, that's the EU, but what about here in the US? What are the laws in place? And you know, historically, there haven't been too many you know, rules or laws in relation to privacy in the US. So you do have, of course, the FTC, who goes after companies whenever they deem the practice to be deceptive or misleading. But then, you know, traditionally, there haven't been you know, too many comprehensive privacy laws. But then, recently, this has changed, and it's still changing because you have more and more privacy laws which are being introduced here in the US. So on the slide deck, I've put in the new privacy laws which are in effect this year. So you have the California Consumer Privacy Act, the CCPA, which already entered into force back in 2020, but then there were certain amendments which were introduced earlier this year. So the amendments applied since January. And then Virginia as well have a new privacy law that has entered into effect in January. In July, we'll see Colorado, Connecticut, and then at the end of the year, Utah. And you know, as we look at you know, the following years, there will be other laws as well: Indiana, Montana, Tennessee, Washington, and so forth. So you know, really, I would say that privacy is becoming more and more a concern for regulators and legislators across the states. In relation specifically, you know, to the types of data which is covered, you know, one point I wanted to highlight as well is that employee data, HR-related data, that is under the scope of California law. So many people don't realize that. But then, in relation to your employees, you do have certain privacy obligations. You have to have certain disclosures as well in relation to data that you collect from your employees. Employees have certain rights, and you have to abide by those in California. You don't see those yet across the other states. So bear in mind this difference. And then in relation to data that you collect in relation to business partners and so forth, that is also under the scope of California privacy law, even though it's not yet covered in the other state laws. The sanctions you can see here on the slide, it can be quite high because the amounts indicated here are per violation. So each violation would it would mean that you would have to multiply the amount by the number of times that an individual has been impacted by the violation. The last point I wanted to quickly mention on the state laws is that in relation to the right of action, individuals do not have the right to sue, so they are not able to bring an action for a violation of the respective privacy law. And in California, the right is limited, so the individuals can only sue in relation to data which was impacted by a data breach. But this doesn't mean that individuals have no recourse, because in effect what they're going to do is that they would just complain to the Attorney General's office, they would complain to the regulators, and then the regulators would investigate, and they would bring in enforcement actions. And in fact, when you talk to regulators, they would tell you that most of the time, the investigations that they begin would be due to complaints that they receive from individuals, and otherwise they would be looking at what's happening in the news, and they also check social media as well to check what's going on, what are the hot topics at the moment, is there any are there lots of unhappy people on social media? And if that's the case, then maybe that gives ground to investigate. Personal data, that's a topic which may seem to be quite obvious, but then it's not always that obvious for everyone, because many times we hear developers saying, well, we don't collect personal data, so the data protection laws don't apply to us. We don't necessarily know the names of the individuals. We don't collect that. We just collect the email address. We have a user account and so forth. So, really, we don't have any personally identifiable information. And, that was valid for many years until recently, because with the new data protection laws, whether it's in the US or in the EU, you have a much broader definition. So you would have this concept of personal data, for example, under the GDPR or even under the new US state laws, where they would say, well, any information that is related to an individual which is identified or identifiable, that is personal data. So the IP address would be one example that is explicitly mentioned in California law, for example, or in the GDPR. You have the email address, which is also another type of personal data. And even if you have a user account or an email address, which is which may appear to be generic, for example, let's say supersecretsquirrel007 @gmail.com. Some of you may be saying, what's that? It's not a name. I can't determine who it is. Well, it doesn't matter. That is under data protection laws. That is information relating to an individual that is identifiable. Therefore, it is personal data. Another big point under the data protection laws would be the selling or sharing of personal information. And I know what many of you may be thinking. We are not selling data. We are not a data broker at Atrium. We are a game developer. So why do we need to talk about this? Well, you have under California law and the other state laws, you have a very broad definition of selling of personal data. So they say that whenever you disclose data to a third party and you get some form of benefit, whether it's money or something else, then that is a sale of personal information under California law. And there was, for example, a couple of months ago, there was this big decision by the California Attorney General against a huge cosmetics company, and that company was fined $1.2 million. And the Attorney General's argument was to say, well, there was a sale of personal information because the company was using analytics. They were using an analytics provider. They were disclosing information because they wanted to have insight on who is using the website, what features are being used. So that it was, there wasn't necessarily the names of the users, but then the analytics provider was collecting data usage information to understand which section of the site is being clicked on and so forth. And due to that, that is considered to be a sale, and therefore you need to disclose it in your privacy notices, and you also need to provide individuals with the ability to opt out of the sale of personal information. And you have quite a number of companies who have been receiving as well over the past couple of months notices from the California Attorney General for violations of the CCPA. So you have, you have one here. So this is actually a screenshot from the Office of the Attorney General, where they mention cases that they have actually looked into. They have anonymized it, so they don't disclose the name of the offending game developer, or in this case, the game publisher. But then they did say that they reached out to a game distributor, and their privacy policy was not considered to be satisfactory. There were certain deficiencies. There was the categories of information disclosed which was missing, and the fact that the company was actually selling personal information within the meaning of California law. And there was no opt-out in relation to the disclosure to third parties. There is another case as well against a game developer, a mobile game developer, where the Attorney General said that there were insufficient protections in relation to minors, that they didn't provide any opt-out mechanism as well, or obtain opt-in for minors. So there are cases against game developers. Children privacy, another big topic as well. You do have quite a number of companies who are often being targeted, TikTok, YouTube, and so forth, where they had to pay huge amounts in fines for violations of children privacy law. Just recently, last month, you had the UK ICO, the Information Commission's Office, who went after TikTok for misusing children's data, for not getting parental consent in relation to data that they collect from individuals under the age of 13. You have requirements under the new state laws as well in relation to design. So this may surprise many of you, because traditionally privacy laws didn't really cater too much about the design choices, but then now you have certain design requirements. For example, in relation to the accept button that you have, is it the same size as the button to refuse? Is it the same color? Is it more prominently placed, and so forth? And if that's the case, be careful, because it is considered to be a dark pattern. The Fortnite case, for example, did mention dark patterns, and it is a new requirement which has been put into the California and the Colorado state privacy law. So you do have requirements. As I mentioned, the size of the accept button, the fact that, for example, you shouldn't have any boxes which are pre-ticked or pre-selected. That would be considered a dark pattern. Do you have any what they call emotionally manipulative language or visuals which are used to push users to click on something? For example, telling them that, yes, I want to miss out on this. That would be considered emotionally manipulative. So you be careful in relation to the language that you use in your apps. Here are other points as well that which are mentioned in the regulations in relation to dark patterns. You mustn't create any false sense of urgency. You cannot use double negatives. You cannot have lots of pop-ups appearing, which may be considered disruptive to the user's experience, because the user will, of course, be tempted to click on the button yes, so that they can get rid of the pop-ups. You need to make sure that you don't create too many steps in order to benefit from privacy options. And then you mustn't have any language which is deemed coercive. You mustn't exploit vulnerabilities of young children. You have to make sure as well that you don't require too many clicks. And be careful as well, because next year you would have the California Age-Appropriate Design Code Act, which will come into effect in July 2024, and then they would also, that legislation will also impose certain requirements in relation to how you design apps and how they may be targeting children and other vulnerable individuals. I'm not sure how much time I have. I'm out of time. Okay. Okay. Let me know if there are any questions. Otherwise, I'm still around here if you have any questions.
Look, thank you very much. That was great.